Chief Justice, members of the court, may it please the court, I, together with Mr. Ali and Ms. Raw, appear for the applicant.
Thank you, Mr. Vanya.
May it please the court, I appear for the respondent with my learned friend, Mr. Lowe.
Thank you, Mr. Booth. You may proceed.
Chief Justice, members of the court, you may be delighted to see that you have quite a narrow record before you. This appeal in turn does raise a very narrow question with what we contend is a just answer. The question that it raises is, when did prescription begin to run on Wanjay's enrichment claim against ATS? Our submission is that the answer to that question is 11 June 2021, when this court delivered its judgment in the University of Johannesburg matter. Because it was on that date that the consequence had arisen that Wanjay was dispossessed of the property and lost the very benefit for which it had paid to Auckland Park Theological Seminary the sum of 6.5 million rands. And if I am ultimately correct in that submission, then Wanjay's claim, which it instituted in March 2022, was plainly brought in time, and Auckland Park Theological Seminary has no answer to the substance of that enrichment claim. If I may provide a roadmap to my submissions, I intend to make 5 submissions. I apologize in advance, they do bleed into one another out of necessity, but there won't be undue repetition. They're as follows. In the first place, I'm going to submit that the debt was not due as contemplated under Section 12(1) of the Prescription Act until Wanjay lost possession and enjoyment of the property in June 2021. Here, if time permits, I will also deal with the straw man argument that ATS has put up. My second submission would be that before that date, Wanjay could not honestly, nor could it coherently, sue ATS for unjustified enrichment, while it and ATS were, as friends, still defending the validity of the principal lease agreement against the University of Johannesburg. My third submission will be that the Supreme Court of Appeal's suggestion that Wanjay should have sought a declaratory order earlier is no real answer to the problem, and it indeed does not meet the facts of this case. My fourth submission will be that ATS has no meaningful factual answer on the merits of the enrichment. It's pleaded loss of enrichment, or as the High Court characterized it as non-enrichment, is on the papers wholly inadequate. Fifth, I will deal with jurisdiction and relief. As I've said, the papers are quite narrow. I may perhaps summarize the background facts preceding my submissions into really 5 sentences, and it's as follows. ATS held a registered long-term lease, notarial long-term lease over the UJ property, and in 2011 it ceded that lease to Wanjay for payment of the sum of 6.5 million rands. Wanjay paid that money, it took possession, and it intended to develop the property into a religious-based school. UJ then challenged the legality of that cession. It treated it as a repudiation by ATS, and it cancelled the lease. We all know that led to prolonged litigation running into almost a decade, a year shy of a decade. But what's important is that throughout that litigation, ATS and Wanjay acted together in opposing UJ's case. They maintained the common position that UJ's cancellation was unlawful and that the cession remained operative. Ultimately, on 11 June 2021, this court upheld UJ's appeal, reinstated the High Court order, and the result was that Wanjay was evicted and the notarial long-term lease was then cancelled. Now that is a critical event because until that event, Wanjay still had possession, still had enjoyment, and still held itself out, together with ATS, to be entitled to remain on that property. So in respect of our first submission, the central question is really one of framing, because that is where the discipline was unfortunately lost. The question that arises is, when could Wanjay enforce its enrichment claim against ATS? In the words of Njongi and those judgments that follow it, when was that claim immediately payable? The court is very familiar with the references that have arisen repeatedly in respect of these judgments dealing with prescription, but for your ease, in Njongi, the formulation arises at paragraph 43. The debt must be immediately enforceable before it can be claimed. And at paragraph 47, what this court reminds us of is that the claim is immediately recoverable, or whether a claim is immediately recoverable, must be apparent from the circumstances that exist at the time that the proceedings are instituted. What we also know from links of this court's judgment at paragraph 17, where it refers to a number of judgments, including Tritter versus Diesel and Deloitte's, you've got to ask yourself as to whether the counterparty has an obligation to immediately perform. So it's the opposite side of the coin. What our submission is as follows. Wanjay could not immediately enforce the claim in the language of Njongi, and ATS was under no obligation to immediately perform in the language of Deloitte before this court's judgment on 11 June 2021. Because before then, the necessary facts to complete the cause of action had not yet occurred. And our submission in that regard, as you would have seen from our written submissions, is anchored in three independent factual propositions. First, Wanjay was not yet impoverished because it still retained possession of the property as reciprocity for its payment of 6.5 million rands. So the judgments like Motokonya and the judgments referred to therein, like Yellow Star Properties, Trutter, Gore, Fluxmans, is of no application to this case, because in this case, Wanjay had not suffered harm until its dispossession after June 2021. In those cases that Motokonya refers to, harm had already occurred, and that was the trigger for purposes of the commencement of prescription. Our second independent proposition is as follows. Wanjay retained a registered notarial long-term lease, reflecting that it held a limited real right over the property. The cancellation of its registration was only finally ordered on 21 June 2021. Until that cancellation, it could exercise rights under the registered notarial long-term lease against all. Our third independent proposition on which our primary submission is anchored is that under the law of lease, a lessee is not entitled to claim until it is dispossessed or its enjoyment is disturbed by a judicial decree. We've referred to the judgments of Loebscher versus Foster and Foster, and we've also referred to the judgment of Donninger versus Thorpe. The respondent's answer or response to this third proposition is that Wanjay was neither a lessor and nor was it a tenant, and so those principles are not applicable. But that answer ignores precisely the substance of what was going on. In substance, what occurred is that Wanjay held the property on the back of ATS, which ATS assured Wanjay that it could do. And ATS's assurance came through for as long as this constitutional court had held out on its judgment on the 21st of June, 2021. So to round off my first submission, this is not a case where a plaintiff sat back after suffering a completed loss. Quite plainly, the loss was not completed until Wanjay was finally deprived of its use and enjoyment of the property. And that deprivation did not happen upon receipt of a cancellation letter in 2012 by Weber Wenzel attorneys. On the contrary, that cancellation itself was hotly contested between ATS and Wanjay on the one hand and UJ on the other hand. It did not even happen when the High Court ruled in 2017, because the matter proceeded on appeal where ATS was successful, and Wanjay continued to remain in possession while the parties maintained their common stance against UJ. The real and irreversible deprivation came only when this court reinstated the eviction order on 11 June 2021. And that was something which, even in the words of ATS, it did not foresee. What this court would have seen is that we adverted the letter that we had received, the email that we had received from ATS the moment the Concord judgment had come down, was handed down. That's Annexure WF4 at page 11.1-77. What ATS effectively said is, we're sorry for your loss. You were good to deal with in business. You have a lot of integrity, but that's not our loss to bear. That was the curt response we ultimately got after a long road of a decade traveling together, fighting the same fight as against the University of Johannesburg. So as a matter of ordinary language and legal substance, we submit that that is when the debt became due. Our second submission is that before June 2021, Wanjay could not coherently sue ATS for enrichment while still resisting UJ's challenge alongside ATS. The Supreme Court of Appeal held that the 2012 cancellation letter gave Wanjay all the material facts it needed, and that nothing precluded it from seeking a declaratory order to interrupt prescription before the UJ litigation ended. That's a proposition that the respondents have embraced. But that suggestion by the Supreme Court of Appeal, as embraced by the respondent, is, with the greatest of respect, a non sequitur. And it's a non sequitur for a simple, common sense reason. Leave aside everything else. There was no Liz between ATS and Wanjay at that time. They were friends. They were acting in lockstep with each other against the University of Johannesburg. And that is no peripheral matter. That is an issue which is central to this case. The simple question that arises is, what would ATS have Wanjay do? Would Wanjay be expected, on the one hand, to hold its hand to its heart and to continue asserting that in the UJ litigation the session was valid and the cancellation was invalid, but on the other hand, go to court, hold its hand on its heart again, and say, well, the session is invalid and we are entitled to claim under the laws of enrichment from ATS? Requiring litigants to take contradictory positions before our courts is, with the greatest of respect, absurd. And with the greatest of respect, it would make a mockery of our court systems. It is not a coherent legal position. It is not commercially realistic. And it is not what the laws of prescription should require, particularly where Section 34, rights of access to court concerns, are engaged. If this court accepts that a claim is not immediately enforceable when bringing it would require the claimant to contradict the very basis on which it is then defending its existing position and rights in pending litigation, then we don't need to enter into the difficult abstractions and doctrinal arguments that may or may not arise in respect of this matter. That, we submit, results in the appeal being disposed of with respect in favor of Wanjay. The third submission concerns the declaratory order suggestion. The Supreme Court of Appeal's reasoning ignored the reality that ATS and Wanjay were not averse to one another in the UJ litigation period. Their reasoning also ignores that courts do not issue declaratory relief merely to express opinions or to answer hypothetical questions. This court, in the not-so-recent judgment of Pridwin at paragraph 50, said as much. To endorse the SCA's reasoning would encourage litigants to treat our courts with, might I mention, its scarce resources as a playground impermissibly seeking the opinion of our courts on hypotheticals, while the real position of whether Wanjay is actually going to be deprived of possession remains in flux. So the declaratory order answer, with great respect, is not only merely unattractive, it is legally unsound and it is procedurally unsound. My fourth submission then goes to the merits of enrichment. If this court concludes that prescription does not bar the claim, Auckland Park Theological Seminary has very little left. The merits issues are completely narrowed. The only issue that arises on the merits is ATS's purported defense of non-enrichment or loss of enrichment. But with respect, that defense is threadbare. When money is paid, we know as a matter of established law, there is a presumption that enrichment arises, and the defendant bears the onus to prove its defenses of non-enrichment or loss of enrichment. And that's what coup de granite tells us at paragraph 21. Against that standard, ATS does not say what it did with the money, it does not say when it ceased to have it, it does not explain whether the funds were used to acquire assets, to reduce liabilities, otherwise improve its estate. In short, Chief Justice, members of the court, ATS does not put up the kind of factual material needed to discharge the onus of proving loss of enrichment. What this ultimately means is that ATS's case is not one of substantive innocence. It is really one purely of a misplaced technical avoidance. If I may now deal with jurisdiction before moving on to my concluding remarks. I deal with jurisdiction last because this court has, in numerous judgments, when it pertains to time bar provisions, whether statutory time bar provisions or contractual time bar provisions, always invoked its jurisdiction in these circumstances simply because it has a bearing on the rights of access to court. It's done that recently in the judgment of LaRue. It's done that more recently in the judgment of Rademeyer versus Ferreira, from old times in Barkhuizen versus Napier, Links, Matokonya, and the list goes on. The bottom line is that this court's jurisdiction is invoked simply because this is clearly a case of a misinterpretation of our laws of prescription, which has the consequent effect of a deprivation of a right of access to court, of the enrichment claim being determined to finality as it ought to. Moreover, this court's jurisdiction is enjoyed also because this is an issue that has not previously enjoyed the attention of the court. It's admittedly a novel issue in this sense that the invalidity of the cession in the present matter is dependent upon a finding whether the principal contract to which the cessionary was not a party was validly cancelled. Now that's something that resides out of the hands of contracting parties in multi-party contracts that are sitting outside of the primary contractual relationship. For those reasons, we submit that this court's jurisdiction is engaged. If I may make concluding submissions, then, they're along the following lines. This is the type of case, this is the archetype case, I would submit, which our courts have invariably spoken of, where there's got to be a fair balance between the guillotine period on the one hand and the need to ensure fairness on the other hand in those cases in which a rigid application of prescription legislation or rigid application of the common law would result in injustice. The injustice in this case is obvious. ATS took 6.5 million rands from Wanjay. Wanjay did not receive the full use of the property as contemplated. ATS itself had previously submitted to this court, holding its hands on its heart, as appears from the UJ judgment, that Wanjay would reclaim the money from it, and it used that as its candidate for purposes of advancing its estoppel argument, as this court may remember. And it used it as a candidate for advancing its estoppel argument on the basis of actual prejudice that it would suffer, not potential prejudice or not a claim that has prescribed. But yet, after the final judgment, ATS refused to pay and instead pleaded prescription and seeks now to retain the proceeds of that session from Wanjay. That factual matrix matters. It matters because it confirms that Wanjay's inaction before June 2021 was not neglect, was not indifference, was not a tactical delay, all of which our prescription laws penalize. It was entirely the natural consequence of the parties' common position that the session remained good and the property remained lawfully occupied pending final adjudication. So this is not a case in which a creditor, by unilateral choice, postponed prescription. Rather, this is a case in which the facts necessary to make the claim enforceable only crystallize upon final dispossession. We therefore ask that this appeal be upheld and that the order of the High Court be reinstated. We also ask for the cost of 2 counsel in the appeal. Those are my submissions for the applicant.
Mr. Babumia, mindful of the distinction between knowledge of facts and knowledge of legal conclusions. And in LaRue, the court crafted a very careful and limited exception to that in relation to claims brought by a client against their former legal practitioner, because the court said, well, if you have knowledge of the fact that your lawyer said you don't need to authorize me in writing to exercise the option, it would be almost unconscionable for the lawyer to rely on that fact as constituting the date on which prescription would run. Now, in the context of this case, this court's finding in June 2021 was a legal conclusion, was it not, in the sense that it said that the session was unlawful, was invalid. And it was a legal conclusion based on a set of facts. And those facts would have been the agreement entered into between the parties, but the court then ultimately concluded that that was. You argue that even if that was a legal conclusion, it was inextricably intertwined with the facts. And your argument today is also that a necessary jurisdictional fact to found a claim for unjust enrichment could not have arisen at any stage prior to June 2021. To what extent would we be sort of muddying the waters and creating legal uncertainty if we, in a sense, uphold your argument? Because on the facts of this particular case, one might say it should be upheld, given the peculiar nature of the facts. The parties were sort of in the same side of the ring for a long time. But it might come back to bite this court and the jurisprudence if in another situation we allow, in a sense, that kind of seepage. Sometimes a particular case might require a departure from clear and coherent legal principle, but that departure could set a precedent in other cases. How do we manage that if we're with you?
Justice Colopin, I'm very alive to the concern that you have, and it's for that reason I have not engaged in a doctrinal excursus that would take you into the realms of uncertainty. I've got perhaps 3 or 4 responses to the issue that you have raised with me. Of course, it is undesirable for this court to muddy the waters, and I would not urge the court to muddy the waters just to come to the rescue of my client. Far from it. The answer actually lies in the manner in which LaRue has been formulated, in the manner in which Matakonya has been formulated, and indeed in the manner in which every other judgment has been formulated. Let me start with Matakonya, for instance. Matokonya at paragraph 38 tells you quite clearly that there are cases in which it would be it's actually difficult to distinguish conclusions of law from conclusions of fact. And what one's got to do, which Matokonya tells us about in paragraph 38, is that you've got to make sure that you analyze the facts of the matter very carefully to draw out that distinction. So that's the first point. The second point is that you've mentioned that the UJ judgment found the session to be invalid. That's something which the respondents also take on as an argument in paragraphs 4, 5, and 24.5 of the heads of argument. That, with respect, is not absolutely accurate. What the UJ judgment was called upon to determine were, by and large, three issues. They were required to determine, was the lease agreement between ATS and the University of Johannesburg a delictus personae? If it was the cession a repudiation of that lease agreement? If it was the cancellation in those circumstances a valid cancellation? Now leave aside the estoppel and waiver arguments. It found in the affirmative for UJ in respect of all three. The consequence of that, the cancellation of the lease agreement between UJ and ATS, meant that the cession could no longer be valid. So we don't rely upon a legal conclusion made directly as against Wanjay in the UJ judgment for purposes of precipitating this cause of action. What we say factually occurred is that there was a legal decree that had been made which had triggered a set of events that resulted in our dispossession. And as a consequence of that, that's when prescription commenced to run. And looked at it from that prism, and that's why I said right at the outset, it really depends upon framing. Looked at it from that prism, there would be no need to muddy the waters. There would be no need to change any of the doctrines in any of the cases. I accept LaRue has been carved out for a very limited exception, and that's as between legal representative and its client, and that is not one of those cases. But what the Supreme Court of Appeal could not do and ought not to have done was elevated the general rule in LaRue for purposes of contending that there can be no facts that would then eventuate, which would result in a cause of action being triggered.
Mr. Babamia, let's create a different set of facts, but similar. At least I see it as similar, and I want to hear your comment on it. Let's say someone was a passenger in a taxi that then got involved in an accident with another vehicle, and as we know, RAF claims prescribe after a certain time. Let's say then the person says he did not lodge a claim because he was waiting for the claim between the taxi and the other vehicle to be determined before he could lodge a claim. What do you think a court should do under those circumstances? Would prescription not run against that person? Or would it then be, a court be convinced that the person was correct in waiting for the finalization of that claim between the two motor vehicles? Or should the person have interrupted prescription?
Justice Chiki, the critical element for the running of prescription on the facts that you have postulated are present. And that is, there is harm, and he's aware of the harm. So in other words, he's sitting in the taxi, it meets with an accident, he's endured an injury. The moment that injury is there, he has sufficient to know of the full facts. As to whether there was negligence on one party or the other party, those are the kind of matters which this court in Links, as well as in Mitokonia, have spoken of as being legal conclusions which ought not to trouble him. Distinguish that from our case. In our case, despite the fact that there was a cancellation letter, there was no impoverishment, in other words, there was no harm. And there was no harm until such time as we were told, pack your bags, pack your creva, leave the premises. You are no longer entitled to retain use and enjoyment and possession of the premises. So
If there's a threat of an impeding harm,
I beg your pardon, I didn't hear that.
if there's a threat of harm,
Well, a threat of harm is not adequate, and one has got to look at the Gore judgment for different circumstances, of course, in the Gore judgment, but one's got to look into the Gore judgment for that matter, because what the Gore judgment also talks about is that you don't have prescription running when there are allegations that are controverted by the parties. Here, there may have been a cancellation by UJ, but that wasn't the final word. The cancellation was dependent upon legal proceedings so that Wanjay could ultimately be evicted.
Sorry to interrupt you. When you say there wasn't final word, what are you meaning? Are you referring to a final legal conclusion? Because I understand the Act to require knowledge of facts. Once you get a lengthy letter from attorneys threatening and intimating that the session agreement is not valid and intimating that if this continues, the situation continues, there might be a legal action that will follow. Is that not enough for you to then say, wait a minute, I'm assisting ATS in this session agreement because I'm part of it, but I should interrupt prescription? Was the rational way not to do it that way?
Justice Chiki, the question that would arise is that assuming we took the letter, Wanjay took the letter on its terms, what was Wanjay required to do? At that point in time, it could not have sued ATS without any more because it still had possession of the property. Assuming it decided of its own accord to dispossess itself from that property, there are a number of unimaginable variables that may have arisen.
Once it sees that letter, couldn't it have approached ATS to then say, there's a threat here, I will, just for the sake of interrupting prescription, commence with litigation, just for the purpose of interrupting prescription? Could that not be done?
That's precisely what I argued against in my founding argument. It cannot be done and it should not be done because that is precisely the kind of thing that makes a mockery of the court systems. ATS and Wanjay in those circumstances will be pretending that they're fighting with each other just to interrupt prescription. Why should they pretend when prescription is indeed not interrupted by virtue of the fact that there hasn't been a dispossession? You would be bringing to court something, a pleading, in terms of which you cannot hold your hands to your heart and say, I believe in the veracity of the allegations that I've made over there. You're actually in collusion with one another, bringing proceedings to court simply to interrupt prescription. With great respect, I cannot see that as being a feasible proposition or path for the parties to embark upon.
Okay. Thank you, Mr. Babamia. On the issue of jurisdiction, this court has spoken a lot about the interpretation of Section 12. And each case obviously will depend on its facts. So whenever cases come, facts will be different, but we know how the court has interpreted Section 12. Should the fact that the facts are different in a matter give us jurisdiction in an established matter, because you know that we don't have a jurisdiction when a case concerns misapplication of an established legal principle.
Yes, I do recall that the contesting argument in the LaRue judgment to persuade this court that it does not have jurisdiction was the misapplication of facts. But ultimately, once we get through the Rubicon, so to speak, and whether you are determining a misapplication of the law or a misinterpretation of the law, the effect is the same. The effect is a deprivation of a Section 34 right under the Bill of Rights. That engages this court's jurisdiction squarely. But we don't say that there was just a misapplication of the law in this matter. We say that there was a gross misinterpretation of the law in the context of novel circumstances, which engages this court's jurisdiction.
Thanks, CJ. Thanks, Mr. Babamia.
Mr. Babamia, it seems to me that the facts were also this, that once Wanjay received the lawyer's letter, after that, it was not able to exercise its rights under the session. That, to me, seems to be a fact that could complete the circle of the minimum facts, the bare facts that it needed to be able to institute an action against ATS. ATS, under the session, the deed of session, had given certain warranties under Clause 7 that you will have vacant occupation and I've paid my rent and all of that. Yet, immediately on receipt of the letter, those warranties and the rights emanating from the session could not be exercised. It had paid the 6.5 million rand, and ATS had been enriched, as we say. Why is not that, does that form a complete set of facts on which Wanjay could have sued, as at in October 2012?
Justice Dambuza, what occurred is that after the cancellation letter, the notarial long-term lease remained, the session remained, and Wanjay remained in occupation. Wanjay, of course, serviced the property for as long as it remained in occupation. It did not lose any rights. So the right that you refer to, or the warranty that you refer to, is Clause 7. Clause 7.1.3 says ATS, and sorry if I may just take you there, it's Annexure WF1, as you know. ATS hereby warrants unto the sessionary, which warranty is material and on the strength of which the sessionary enters into this agreement, that as at the effective date, it is not in default of any of the terms or conditions of the lease. What you have is you have an assertion by UJ that on its view, and its view, of course, had differences of opinion from the High Court to the Supreme Court of Appeal and ultimately to the Constitutional Court, that it wasn't in breach of any of the provisions of the lease. As a consequence of which, ATS permitted Wanjay to occupy the property. So there was nothing lost. As to whether Wanjay decided to hold back in terms of putting up structures and so forth, that's not a loss of its right. That's an election that it makes in terms of commercial realities to weigh up risks. But for as long as it's got what the lease agreement provides to it, in other words, the right of occupation and the right of possession, it hasn't suffered any loss.
But it seems that Wanjay had resigned itself to the fact that, look, I cannot exercise my rights here unless I go to court. Isn't that on its own a complete set of facts? That I can't exercise my rights here under this session. Whatever the court will say, I'm not interested in that. I concluded this agreement for a specific purpose, which I now cannot realize because of this letter. The fact that it chose to retain the notarial the registered notarial deed, isn't that also its election and it driven by its own view that, look, I think I am right that UJ doesn't have a valid action, a valid cause. But that's besides the point. As between itself and ATS, it knew that it had accepted that it's not able to exercise its right under the session.
Justice Dembuza, just two submissions. The first is that Wanjay wasn't required to go to court for purposes of obtaining legal certainty. It was the other way around. It was the University of Johannesburg that needed to go to court to have its cancellation effectual and to ultimately then obtain the eviction of Wanjay from its premises. So in other words, it's cancellation against ATS effectual and then the eviction. Up until that point in time, what you had was a contestation between primarily ATS and the University of Johannesburg. But while that contestation had taken place, you had ATS that had said to Wanjay that you can still occupy these premises, and they did. As to what
the main list had been cancelled by UJ. Didn't UJ cancel the list? UJ. In other words, the main list had been cancelled, and that's what rendered everything else that emanates from the main list or that ensues incapable of performance.
Justice Dembuza, the cancellation of the lease is of no moment to this matter. And the reason I say that it's of no moment is because the cancellation was contested. And for as long as it was contested, an important ingredient for purposes of an enrichment claim was absent. There was no impoverishment. There was no dispossession. And in the absence of the dispossession or the impoverishment, your prescription legislation under Section 12.1 is simply not triggered.
Okay, I think it will go back to what Justice Chikri raised, that then Wanjay elected to go to court so that it could have certainty of the legal certainty about the validity of all these documents or these agreements. But thank you, I hear you.
Justice Dembuza, may I just correct that? Wanjay did not have to go to court. It did not go to court. There was no Liz between the University of Johannesburg and Wanjay. There was a Liz between the University of Johannesburg and ATS, which had consequences. What we rely upon is not that Liz and the legal certainty emanating from that Liz. We rely upon the consequences that trigger those facts.
Well, as to who the litigation was between, I don't think it matters much. What matters is that Wanjay opted to wait for a court decision, a court pronouncement on the validity of the lease between UJ and ATS. it wouldn't have chosen to go to court, not because the facts that I set out, that, look, I'm not able to exercise my rights, are not in existence. There doesn't seem to be contestation as to that. And ultimately, this is what's happening now between Wanjay and ATS, in that what Wanjay is saying now is what it could have said in October 2012. It seems that you got the money, I paid you, but I'm not able to exercise my rights, and therefore you've been unjustly enriched.
Justice Tembuza, but that is a missing feature in the respondent's case, because the respondent doesn't identify what rights I'd lost which would have the effect of triggering prescription. Our central case, and we've really just got one central point in this matter, it's the dispossession that triggered prescription. If I'm right on that, I should win this appeal. If I'm wrong on that, I should lose this appeal. But it's really that narrow point. It really comes down to whether the dispossession features as a central theme for purposes of this court's judgment or not. But it's not something that has been touched upon by the respondents.
Babamia, just following up on this line of questioning, there are 4 minimum facts required for this unjustified enrichment claim. ATS must have been enriched by 6.5 million. You must have been impoverished by the 6.5 million. There must be a link between the two, between the enrichment and the impoverishment. And fourthly, that enrichment must have been sine causa. In other words, that the session contract was invalid. Now here, it seems to me the crucial one is the last one, the sine causa element. Is the fundamental difficulty, can I just interrupt myself and say, on the equities, I feel for you, but we're not a court of equity, we're a court of law. So having said that, is the fundamental flaw in your case, the entire basis on which it is brought, is that this court, when it gave judgment in the UJ case, that did not render the session void. The session was void ab initio. You say so yourself in your papers. It's a 001, case lines 00124, I think. Paragraph 74.1, you say it is common cause that you, is it Ms. Ali or Mr. Ali speaking, it is common cause that ATS received payment of the 6.5 million from Wanjay in terms of the session agreement, which session agreement was invalid and void ab initio. So what this court said in 2022, was it, or 2021, didn't render the session void, it was void ab initio. Is that not the fundamental problem in your case?
Justice Majid, it's not, for this simple reason. Generally, in a linear relationship where you're dealing with enrichment causes of action, and it's a general principle, of course, they say prescription commences to run at the time that the unjustified transfer had been made, and that is as a consequence of that void ab initio agreement. But that general principle is not an immutable principle, and it's certainly not an immutable principle viewed from the prism of the Prescription Act. For purposes of prescription, it's not the tail wagging the head, it's the other way around. You don't ask, when did the enrichment cause of action arise? You ask yourself, what does prescription require of you? Prescription requires of you to answer, when is the debt claimable? When is performance due? When is the debt enforceable? Now, that is a fact-sensitive inquiry, and it's not a one-size-fits-all on the basis of general principles of enrichment law. In this present case, unlike the other enrichment cases that one deals with, where you have two parties and there's an agreement that has been concluded and suspensive conditions have not been fulfilled, and you know a certain long stop date as to when the suspensive conditions needed to be fulfilled and the like, you would have time and you would have the ability to then bring your claim within the time period. This case is somewhat different. This case detracts from the certainly not so immutable general principle of enrichment law, because you've got to ask yourself the question, apart from the sine causa, when did the impoverishment take place? It may be that ultimately, because UJ was correct in contending that its cancellation was effectual, that the cessionary agreement or the subsidiary agreement was void ab initio. But that matters not. What matters is whether you fulfill the other requirements of enrichment. Was there an impoverishment at that point in time? And if the answer to that question is no, there was no impoverishment, then prescription doesn't commence to run. Was there an enrichment at that point in time? The answer is no. ATS still, while fighting against UJ, ensured that you remain in occupation of the property. I couldn't satisfy the requirements for enrichment in those circumstances. Once again, the answer then becomes prescription could not have commenced to run.
See, the rationale for your possession of that property was based on a cession. And once you say that the cession was void ab initio, once you accept that, it just seems to me you have an insurmountable obstacle. But I've heard your answer. I don't want to dwell on it. Move on. My colleagues have alluded to the letter of 5 October 2012. That was the first caution you got. Then on 10 March 2017, there was the judgment in the High Court of Victor J. in Gauteng Division. And then on 4 July 2018, another judgment of the full court in the Gauteng Division. So on these three occasions, at least by the earliest 5 October 2012 and by the latest 4 July 2018, you've had these cautions that this session is void. Now, how can the court excuse your inaction based on you drawing the wrong legal conclusions from all of this? Whether you agree with the judgments on the letter or not, surely we can't allow you to say, well, I drew the wrong legal conclusion, therefore you must excuse me. This is not a Leroux case. I think you've conceded that. Leroux is a very narrow exception. So on what basis can the court excuse your ignorance and actually disregard of these three warning signs that came?
Justice Majid, you're quite correct. This is not a Leroux case. But the issue is not about the warnings, because that's precisely what they were. They were warnings. You've mentioned the High Court judgment in 2017. You've mentioned prior to that, of course, the letter of October 2012. And you mentioned after that the full court judgment of 2018. There was also the Supreme Court of Appeal judgment after that, which disagreed with the full bench as well as with the High Court. The point that I make remains the same. Throughout this period, those warnings did not manifest into firm events resulting in dispossession. The Supreme Court of Appeal's judgment did not result in dispossession, and nor did the preceding judgments. The dispossession itself, in other words, the fact of the impoverishment and the corollary of its enrichment, only arose when this court handed down its judgment. So the issue about the warnings or the cautionaries are of no real moment in the context of the factual assertion of impoverishment and enrichment.
Now, do I understand your case correctly? And I think you've said so to one of my colleagues who asked you questions earlier. Your case, as I understand, is that Wanjay had no standing to contest the validity of the lease agreement as between UJ and the seminary. That is your case. Am I right?
Indeed.
But as I see it, it misconstrues the basis of why the cession agreement was invalid. It wasn't invalid because the lease agreement was validly repudiated, which is what you say you couldn't challenge. It was invalid because it was a delectus persona and couldn't be ceded.
The delectus persona was the rationale for the repudiation. In other words, for an affirmative finding on the repudiation as I understand it. Assuming that the court found that it was not a delectus persona, as one of the three courts had found, well then of course there could not have been a repudiation. If there could not have been a repudiation, the cancellation would have been ineffectual. So the delectus persona is of course, as I said, the rationale which triggered the ultimate conclusion. And it's only when the ultimate conclusion of cancellation was triggered, that's when it in turn unleashed a new set of facts of dispossession.
I must just say that there is a problem in this case that I say just in passing that it seems to me that the High Court in its judgment, and I'm generalizing now, relied only on Section 12.1, whereas SCA relied only on Section 12.3. Both of them are wrong. You don't read the Prescription Act like that. You read it holistically. In fact, those two sections cross-reference each other. I'm just saying that in passing. Now, you see, we as a court, as we have said over and over again, we've said so in Leroux, we've said it in Mtokinyane, we can't allow a situation where a litigant can say, as I've said before, excuse me from drawing the wrong legal conclusion, because then it means that person's not au fait with the law would be able to use that as an excuse all the time, and that fosters uncertainty, and it's just not sensible law. I think you accept that.
Justice Majid, I do accept it, and I do accept this court's judgment in a variety of cases where it has spoken about the virtues of having a guillotine period for purposes of advancing claims. And like I said, you know, I would never want this court to muddy the waters just to come to the benefit of my client. I think it's about an appropriate interpretation of the laws. But having said that, I think the key factor over here, as it was in every other judgment, is you've got to look at when the harm had occurred. If you are with me on the fact that the dispossession equates to the harm, then I should win this appeal. But if you are against me about the dispossession equating to the harm in the context of this matter, then I will lose the appeal. But it really boils down to that narrow issue. But the one thing for certain is that there will be no upsetting of the law in those circumstances.
Since we are talking about dispossession, that brings me to what is almost my last question. You say that you were only impoverished when you were evicted pursuant to this court's order, because before that you'd retained the possession of the property and you had this notarial long-term lease. But it seems to me that that question of reciprocity, you have a long-term lease, you have possession, and because you have paid, that is a feature of contract. Reciprocity is fundamental to the law of contract. But unjustified enrichment claim works differently. It's not based on contract. It's not the reciprocal action of having paid and therefore getting possession. It's based on the fact that there has never been, in this case, a valid cession. So it seems to me it's improper to say, based on the fact that I've paid and I've got possession, I couldn't proceed, and because I hadn't been impoverished.
That's correct. The reciprocity element of it is a creature of our law of contract. However, we don't ignore the contract because it was the void contract that resulted or precipitated the payment on the one hand and provided the occupation on the other hand. In other words, let me speak in classic terms, in the erroneous but bona fide belief that the agreement was valid, I made overpayment. Having made overpayment, I received possession. I am now impoverished as a result of me not having that possession any longer, whereas you are enriched as a result of retaining that 6.5 million rands, which was made pursuant, of course, to the void agreement. While reciprocity, of course, is the language of contract law, it doesn't take away from the fact of the payment having been made in terms of a void contract and possession having been obtained in terms of a void contract. The ultimate issue, of course, that resides over here is when do you lose, for purposes of claiming impoverishment, that possession because you don't have your possession, nor do you have the money which you had paid over under that void contract.
Further problem with this impoverishment argument, and I'd like to take you to the pleadings in the High Court. This is at case lines 011 1-13, it's paragraphs 33 and 34, it's at the conclusion in your founding affidavit. Just going to see if I got that right.
That's the concluding paragraphs.
That's the concluding paragraphs. It's something you repeat in this court. I can just tell you that in your written submissions, and I'm going to go to the, perhaps that's easier. Let's go to your written submissions. I see you, I've been prompted with the case lines. It is the correct one. At page 14 of your written submissions, paragraph 32.2. You say that you've been impoverished by the payment of 6.5 million, but as I understand this pleading in the High Court, you say that that impoverishment is as a consequence of the loss of use and enjoyment of the property. Is that what you pleaded? I just want to understand your pleadings correctly, otherwise I wouldn't put the question if I'm wrong. So just to summarize, you say you've been impoverished because you've lost 6.5 million because of that payment. You didn't plead that it is for the loss and enjoyment of the property. If I'm wrong, please show me in the pleadings where I'm wrong. I hope you understand my question, Mr.
I do. If I may paraphrase, you're saying that I link my loss directly to the loss of the 6.5 million as opposed to the loss of the use of the property, the possession of the property.
You put it much better than I did. Thank you.
That's a rare moment. Justice Majid, if I may ask you to refer to paragraph 23 of the founding affidavit. The allegation is made in paragraph 23, but the end result is that the applicant had parted with its money and is not in possession of the land. In other words, if it were remained in possession of the land, of course it could never complain about the impoverishment of the 6.5 million rands, but because it has neither, it's entitled to return of the one once the enrichment claim is perfected.
But are you not in effect saying there too that your impoverishment is due to your eviction, your loss of possession, and not due to parting with the 6.5 million? The difference between the two, as you'll appreciate.
I'm not sure that I can agree that there is a difference between the two. The one is the consequence of the other. If I can play it out in the following manner, a possession was obtained as a consequence of paying the sum of 6.5 million rands. When possession was taken away, and that was something I would never ever be able to get back, I'm impoverished by the sum that I had paid for that possession.
Last question is your alternative argument, as I understand it. And I'm looking at paragraphs 62 and 63 of your written submissions at page 27. You submit there at paragraph 62 that if we consider the SCA judgment to be in accordance with the legal exception rule that was created in LaRue, then as I understand it, we should extend the limited exception for the protection of Wanjay's Section 34 right of access, as you put it, and then you enunciate that further extension of the limited exception in LaRue. It's quite a mouthful, but you know what I'm saying. We should extend it in the terms more or less in paragraph 63. Do you persist with that argument?
Justice Majid, in preparation for this matter, I concede that that is an inelegant thing for this court to do, and the court need not trouble itself with creating even further exceptions. I think all that the court needs to do is interpret the Prescription Act in accordance with the Constitution as required by Section 39 on the facts of this matter, and no more than that.
Thank you for that. It makes our task a little bit easier, because it was going to be a long shot to extend it further than LaRue, because we've agreed that it was to fit in with cases of professional negligence, to bring lawyers into the same mold. My last question, I promise you, is a further question that seems to me geared at your alternative argument. You raise estoppel. Do you persist with estoppel?
Justice Majid, no. I see there are contestations in the respondents' heads of argument as to whether it was abandoned in the High Court and in the Supreme Court of Appeal. I was not there. I do not wish to give evidence from the bar. And if my primary argument remains my primary argument, you need not trouble yourself with estoppel.
Again, thank you for making our task a little easier, because, again, that one is also going to be a long shot on the pleadings and on the law. Can I just conclude, and I say this not only because morally I feel for you on the equities, but also I think it needs to be said. One appreciates it when counsel abandons points that really take you nowhere. And I really want to thank you for that. It narrows the focus of the case, because this is really a narrow focus in this case. So I'd just like to express my personal appreciation for that. Thank you. Thank you, Chief Justice.
Mr. Babamia, when you kicked off your argument, you listed five points that you said you were going to address us on. Jurisdiction seemed to have been the last point. I was wondering whether the reason it was the last point, was it because you thought you already had your foot at the door, or it was an issue not seriously contested?
Justice Matopo, I'm going to say this with a certain level of embarrassment. I thought of dealing with jurisdiction last only because in the structure of my address, that seemed to be a more coherent fashion in doing it. But I have addressed all points, and I've taken all points with the seriousness that it deserves.
But do you realize that for you to have any audience or hearing, the first point or the first box that you have to tick is jurisdiction?
I accept that.
So I just want us to start at the beginning on the jurisdictional point. In your papers, in your application for leave to appeal, when you talk about how this court's jurisdiction is engaged, I'm not using the case lines. You say, these are the points. You are focusing so closely on the Section 34 rights, and you round it up by saying the SCA's restrictive interpretation of the legal conclusion rule is the kind of strict interpretation that this court has held to infringe the right to redress through our court, so raising a constitutional issue. Let's pack it there. At the High Court, at the SCA, this was not an issue. Am I correct? That this constituted a constitutional issue.
Justice Mutopo, I was neither at the High Court nor at the Supreme Court of Appeal.
When we're
but
looking
what
at the record,
yes,
whether you were there or not, I wasn't there.
yes, of course, I'm making submissions from the record, and from the record what I understand is that in the replying affidavit, the Section 34 challenge had been raised in the replying affidavit before the High Court. I understand that the LaRue judgment was debated before the High Court. The SCA is correct that LaRue doesn't find application in this case.
And you've conceded also that it doesn't find application.
I've conceded it doesn't find application. Where we do take issue with the Supreme Court of Appeal's judgment, and this is what that paragraph that you had read out to me goes to, where we do take umbrage with the Supreme Court of Appeal's judgment, is where it seeks to elevate this legal conclusion rule into a golden rule, forever in the day precluding a cause of action that may be triggered. What we say is that this is one of those type of cases whereby judicial decree by a court in the UJ matter, it precipitates a set of events that results in an impoverishment to my client. And we say that had the court not taken that restrictive approach, which is a restrictive approach in violation of Section 34, it would have reached a different conclusion altogether.
But you would have realized, as you did your preparations, that if you were to put your argument on jurisdiction, on the legal conclusions, there will be a body of authorities that seems to be against that proposition. And I'm not on the merits. I'm purely focusing on whether we have jurisdiction to hear this matter. If you are wrong, or if the respondents are wrong, or the respondent's wrong on jurisdiction, you don't get into the merits. So what I'm testing with you is whether this is a constitutional issue that requires adjudication by this court. And if it isn't, then you don't come in. But if you come in through a limited or restrictive basis, we have to test that whether that restricted or limited basis grounds jurisdiction. What is the point that grounds jurisdiction?
The points are threefold, Justice Matopo. The first point, of course, we say is the narrow interpretation by the Supreme Court of Appeal, as you would see from paragraph 16 and 26 of their judgment, in terms of which they seek to elevate the legal conclusion rule into a golden rule that doesn't permit you to have any other cause of action. That's our first basis. The second basis, of course, is we say that because of its incorrect interpretation of the law, that has the consequence that it violates our rights under Section 34, an archetype engagement of the Constitutional Court's jurisdiction.
But when you read the Mutokonya judgment, the Njongi, the Yellow Star, the majority in Rademeya, do you tick the box?
Justice Mutopo, with respect, we do tick the box. When I read the majority in Rademeya, when I read LaRue, when I read Njongi, as well as when I read Links, what was foremost in the minds of this court is the fact that they were determining an interpretation of Section 12 of the Prescription Act, a piece of legislation which in and by itself has a preclusive effect as against your rights of access to court.
But is it not a tried and tested principle that Section 12 of the Prescription Act limits one's rights to access to courts? And there's a rationale for Section 12 is that there should not be endless and unmeritorious litigation. That's why we have Section 12. And that is why you are not attacking the constitutionality of Section 12 before us.
Justice Mutopo, none of the applicants in those other cases were attacking the constitutionality of Section 12 either. What they were attacking were the consequences of the manner in which Section 12 had been interpreted by the courts a quo, or by the Supreme Court of Appeal in those circumstances.
So let me not misunderstand you. So are you attacking it, or are you attacking the manner in which Section 12 has been applied? If you are taking the manner in which it has been applied by the SCA, then that would be a misapplication of the law which does not engage our jurisdiction. If it's a misapplication of the law, it does not engage our jurisdiction, then you don't get in.
Justice Matopo, I appreciate the distinction that you make, and that was a question that was asked of me right from the onset. I attack the misinterpretation by the Supreme Court of Appeal of a law that has a preclusive effect for purposes of Section 34. That's the one part of my argument. The second part of my argument, of course, is that these novel set of facts has never been engaged by the court, and so we come in terms of Section 167(3)(b) as well for those purposes.
No, I don't understand it. You must explain it. But if you say the first part, we've debated it, I don't want to belabor it. But if you say these novel set of facts, this court does not deal with the facts. On the facts, you're out as well. Now, what is so novel about these facts that would require that we must deal with it? The underlying rule is this court does not engage in matters of facts.
Justice Matopo, that with respect is partly correct. If there are the type of facts that arise before this court that have never been tested by other courts and that have further implications down the line for future courts, then one's got to test the laws in relation to that.
You know, an appellate court, it's slow to interfere, slow to adjudicate question of facts. You know, that's a rule, you know. You don't venture there.
Justice Matopo, I am not asking this court to interfere with the facts. In fact, I am saying something quite different.
Okay.
What I am saying is that the facts of this matter, the novelty of the facts of this matter, raises an issue of interest for this court as to how it would apply the prescription laws in relation to facts of that nature. I'm not for a moment suggesting that the facts have got to be interfered with.
Let's take the novelty of the facts. The novelty of the facts is what you had been debating with my colleagues here, to say the facts are that when the letter of cancellation was sent, right, those were the minimum facts that were available to Wanjay to say, we may be having a problem. This is what Justice Chikri and Justice Dambuza canvassed with you, to say, we are facing a problem. And at that time, one would pose it a question, did you have the necessary facts at that time to enable you to identify whether you would have a course of action against ATS? Indeed you would have. Indeed you had. But because you were in a lockstep inquiry or maneuver, that's why you did not exercise the facts. But when you go back to ascertain and say, when did Wanjay acquire the facts? Wanjay knew as early as when the letter of Weber Wenzel was sent that the lease has a problem. And if the lease has a problem, Wanjay would have asked itself, we're talking about the novelty of the questions now, would have asked itself, if a court going forward were to find that against us, and then you have to trace your step backwards. Tracing your step backwards, did we know at that time? Yes, we knew. What is it that we wanted to know? We wanted to know the legal conclusion, right? The legal conclusion came through the judgment of this court some 7 years or 8 years later. But when did you acquire knowledge? Back then. Now, this is what Justice Chiki was saying when she gave an example of two motor vehicles involved in an accident. And then you responded positively that the injured person would have suffered harm. The injured person would know that I have suffered harm and would not be expected to adopt a supine attitude and say, let me wait when the two protagonists have resolved their issues and then I'll decide whether I have a claim or not. At that time when she suffered the harm, that's when she had the bare minimum facts to institute an action. So what is novel about that? So I'm raising the novelty argument in the context of your submission that it should engage our jurisdiction. I hope you follow my example.
I do follow the example,
Yeah.
yes, thank you.
Well, it may be a bad or good example.
No, that's usually the difficulty with all examples that all of us can be guilty of. Justice Matopo, the fine point here is along the following lines. The novelty of this case is not, as I've mentioned, the linear relationship between two parties to a contract that were required to perform, as a consequence of which an agreement had fallen through, because let's call it for want of compliance with a suspensive condition. The novelty of this argument is you're dealing with multi-parties. You're dealing with UJ and ATS that were parties to a principal agreement. You're dealing with Wanjay that it becomes a party to a subsidiary agreement, the session agreement. And the event, and that's what Mutakonya at 38 talks about, the difficulty with sometimes ascertaining the difference between legal conclusions and facts. The event that precipitated the loss, the harm in the example of the person sitting in the vehicle of the taxi driver, only occurred after disposition, and the disposition itself only occurred after the UJ judgment.
But Mutakonya is, the majority says differently. It says, I've got here in my notes, that the majority concluded that Section 12.3 does not require knowledge of legal opinions or legal conclusions, or the availability in law of the remedy. This is what it says in paragraph 36. And it says, the creditor must have knowledge of the facts, not legal conclusions of law. And Yellow Star at paragraph 37 confirms it. And Yellow Star goes on to say, failure to appreciate the legal consequences of the facts does not delay the commencement of prescription. In other words, you can't wait for the legal conclusion when you have the facts. Please understand that my questions are focused on, not on the merits, even though there's an overlapping, but on the jurisdiction, whether in the light of these authorities, which confirms the legal position, is there any legal position that we should be engaging with because the law is settled?
Yes, Justice Matopo, may I draw your attention to paragraph 38 of the judgment you've read from 36 and 37. 38 talks about the reference to knowledge in terms of section 12.3
Which one? Is that Mutakonya?
Mutakonya, indeed, yes. The reference to knowledge of facts in 12.3 raises the question of what question of fact is as distinct from, for example, a question of law or a value judgment. The court, the majority there, says the distinction between a question of fact and a question of law is not always easy to make. How difficult it is will vary from case to case, and then they refer in turn to the Persco judgment immediately after that. What our case really hangs on, for purposes of invoking this court's jurisdiction, is precisely that. It's precisely the difficult cases, the novel cases, the novel facts under which there is a difficulty to distinguish between a question of fact and a question of law.
You see, the problem why I'm raising this is we have been accused of sending different, as the court, as sending different signals to the litigants to a point where they are confused as to what is it that actually engages our jurisdiction. But if the law has been settled, we should send that message to say, what the applicant here is inviting us to do has long been settled. We can't, or we can on this basis. And the basis that I and you have debated upon, I have not seen it in my mind formulating or to use your word, crystallizing to warrant this court's having jurisdiction.
Justice Mutopo, in respect of your first concern pertaining to the signals that, of course, the court sends, as far back as Motokonya already, that was some 8 years ago, the law was settled insofar as prescription was concerned. There was no difficulty with it, but it engaged the court's jurisdiction for a simple reason. It engaged the court's jurisdiction because of those peculiar facts which had arisen in the context of the interpretation of the Prescription Act. And the court tells us that it doesn't tell us in specific terms, but what it does in paragraph 9.
But sitting in your chambers, you would ask, as far back, we've had Motokonya, we've had Yellow Star, we've had the Flaxman also. And the Constitutional Court has said in the Wanjay matter, there's jurisdiction, it has jurisdiction. What is it that this court says gives it a distinctive jurisdiction in this case? You're sitting in your chambers, you'd ask, you're preparing for another matter. Now the question would be, is there a proper basis made for jurisdiction? Or is it on case-by-case basis? That can't be right.
The short answer, Justice Mutopo, sitting in my chambers, is that I would look at the various paragraphs of these judgments and see whether there is a constitutional point that has been implicated like they have in these judgments. For example, paragraph 9 of Motokonya tells you specifically why the jurisdiction of this court is engaged. Our case is no different from the perspective that a misinterpretation of the laws of prescription implicates this court's jurisdiction because of the deprivation of our Section 34 right. As I've said, I've made that submission before, of course. That is our first basis. Our second basis, of course, is the novelty of these facts in relation to the Preclusive Prescription Act.
And you would say you enjoy prospects and also the interests of justice require that we must hear this matter.
Justice Mutopo, if my argument on possession or dispossession is correct and it's linked to the elements of enrichment and impoverishment, then I submit that we do enjoy reasonable prospects of success for purposes of engaging this court's jurisdiction.
Just hold on. I'm not sure if that's what you put forward in your application for leave to appeal. Would be the one, or no, possibly there is, I say it here, sorry. No.
To assist you, Justice Mutopo, we deal with it from paragraph 60.
I saw it. And then you don't rely on Radamea. I was wrong in Radamea. You can't rely on Radamea.
No,
The passage in Radamea to which the majority carefully thought it should not be commented on, I was wrong there. You can't rely on it. I was a minority.
No, I don't rely, Justice Mutopo, I don't rely upon your judgment, your minority judgment in Radamea. Where we do make reference to Radamea, particularly in our written submissions, is about the absurdity in bringing two contradictory causes of action. I know that was a different case, and I know that had to deal with specific performance and a subsequent damages claim. But it's really by parity of reasoning of how litigants shouldn't contradict themselves in particular proceedings which they bring before the courts.
But its relevant is not relevant in these proceedings.
Not the judgment itself, you're quite correct.
Yeah.
It was just an extract for purposes of advancing some reasoning.
Well, let me conclude. Are you submitting that despite 3 warnings, the 3 warnings being the letter, the judgment by Victor J, and the judgment by the full court, still you could not do anything and you had to wait for the legal conclusion that came in on the 11th of June 2021? If a litigant were to say, because I was locked up in litigation, trying to challenge the validity of the cancellation of the lease, you must construe my application or my case to be that despite that letter, despite Victor J's judgment, despite the full court judgment, I could still sit pretty and say, I'm not doing anything, I will wait. And I waited. And what is the train that you're waiting for? I was waiting for the determination that the lease was valid or not. When I had been advised right in the beginning to say it's void ab initio. So could you wait for that bus when there were 3 buses that went by and wait for the big bus? Was it worth the wait?
Justice Matopo, with the greatest of respect, that wait was necessary. One's got to take the full conspectus. I mean, if we're going to unravel facts to see what ought to have happened in a hypothetical situation, we've got to take the alternative hypothesis into account as well. And let's take the alternative hypothesis into account. You've mentioned 3 warnings: the letter, the High Court judgment, the full court judgment. The SCA found otherwise. It could have ended at the SCA, but it didn't. It came all the way to this court.
No, it came all the way to this court because we said it must come here. It means nothing.
No, indeed. But if you allow me to develop my submission, the important point here is that the cancellation of the primary lease was in a state of flux. Let's play this out. Assuming my client decided to give heed not to a factual event that actually resulted in its dispossession, but he decided to give heed to a warning, a fire shot in the air. And he decided to turn to ATS and say to ATS, well, I want out of this agreement simply because there was a warning shot that was fired. And let's assume that ATS in those circumstances said, very well, I consider your conduct a repudiation of my agreement, and I'm going to exercise my rights pursuant to that repudiation. And let's assume that in those circumstances, ATS was successful in one of those courts.
No, sorry. ATS would say what to your client?
That I'm going to sue you consequent upon you repudiating the session agreement because I decide to walk out.
No, but your client would have a perfect defense to say, UJ has now said you could not transfer more rights than you actually have.
No, but Justice Matopo, this is the proposition I'm testing, if you allow me to develop it fully. Assuming that my client, at the first firing shot, decided that it's walking away from the session agreement, and assuming that ATS was then ultimately successful in resisting the cancellation, what then? If ATS was successful in resisting the cancellation, my client would have had to incur the damages of a repudiated contract. And of course, unnecessarily so, it would have no defense to that repudiation because a firing shot is not a defense. What is a defense is its ultimate dispossession.
I can take it no further.
Mr. Babamia, just on the point of, you've canvassed it slightly with Judge Majid, is the factual dispossession really the impoverishment when, in fact, the enrichment by ATS of the 6.5 million rand, is that not really where the enrichment arises?
Justice Savage, for as long as ATS provides possession to Wanjay, it's not enriched. So there is a correspondence in time, or corresponding time for purposes of the enrichment as well as the impoverishment. The main feature, of course, is the dispossession, because the moment of the dispossession means that Wanjay has neither its money nor its property, and that means that ATS, because it is unable to give possession of the property that it had undertaken to do originally, is sitting with money that it should not be sitting with. So it corresponds.
But if you accept that if ATS is enriched by 6 million rand and Wanjay is impoverished by 6 million rand, then it turns on the money. The claim, in fact, is a money claim. It relates to when the payment when one party was enriched and the other was impoverished. Then it is, in fact, not the factual dispossession around which your claim turns. It's in fact the payment of the funds in consequence of the session.
Justice Savage, but you don't know when the impoverishment arises until there is the dispossession.
And then just in relation to the session, at what stage did the fact arise that the session was void ab initio? When did that fact materialize?
That fact was a consequence of the UJ judgment. As I had submitted earlier on, the UJ judgment didn't deal directly with the session itself. It dealt with the primary lease agreement, and it dealt with the three questions in respect of the primary lease agreement. Delectus persona, if yes, repudiation, if yes, effectual cancellation. Of course, the consequence of the effectual cancellation would mean that the session could not withstand.
But is that in the nature of an ab initio invalidation? It was from its commencement invalid. So is that not the date on which, is it not the date on which, can you really say it's the date on which the court confirmed that the session was void ab initio? That is the fact that makes the session void ab initio?
Justice Savage, as I've said, that in terms of the general principles of enrichment law, I accept that the rule is, and it's not an immutable rule because one's got to look at the facts that have arisen, but the rule is that you've got to look at the date of the agreement being declared, not declared, the date of the agreement having been concluded, and it's the date of the undue transfer that triggers prescription ordinarily. But of course, as I've even previously submitted, it's not the tail wagging the head. One's got to ask, for purposes of prescription, when is the claim enforceable? Is it always enforceable in terms of this immutable principle, or is it enforceable when you have all the facts necessary for you to institute proceedings, like, for instance, in our case, which is a central feature of our case, the harm or the loss?
So do you rely on 12.1 or 12.3?
Justice Majid quite correctly pointed out that they all have to be read together, and I agree. And I agree that, of course, it was wrong for both courts to have taken an approach that were different from each other. Neither were correct. But in the context of this case, before you even get to 12.3, you've got to ask yourself, is there a debt that commences the running of prescription? So if we're talking about it in terms of 12.1 and 12.3 language, then you start off with 12.1 and you say, is there a debt capable of commencing to run for purposes of prescription? You answer that question by reference to whether there is a claim that's immediately enforceable. If there is no debt at that point in time, you don't even engage the 12.3 debate.
So your argument is in essence that you were not aware of the fact that the session was void ab initio. That fact did not exist as at 2012.
Justice Savage, my argument is somewhat different. It's not about awareness of the facts. So in other words, the respondents raise the 12-3 argument in when one ought to have been aware of things. My argument is slightly different. My argument is that there was no debt until such time as I had suffered a loss.
Thank you.
Mr. Babamea, can I take you back to jurisdiction? You mentioned 3 points when you were canvassing it with Justice Matopo, the last one of which was relating to novel facts pertaining to this case. But that would not be a constitutional issue. You'd agree with that, huh?
Justice Nuku, I haven't come across any case authorities, and I've asked my colleagues to my left as well to take a look at it in advance of this hearing, where the Constitutional Court has dealt with prescription in the context of an enrichment claim on these particular facts. And
sorry to interrupt you. My question is slightly different. Because this court either has jurisdiction because it's a constitutional issue or it's an arguable point of law. On my reading of your pleadings, you solely rely on the constitutional jurisdiction. Am I correct?
on our application for leave to appeal, if I may take you there, Justice Nuku. We deal with it from paragraph 69 all the way to paragraph 78.
Just give me a sec. I'm looking at paragraph, you plead jurisdiction 69 to 71. 3 paragraphs.
Yes, and then we deal with the interests of justice.
In 69, you put it 1673B, Roman numeral 1. At paragraph 70, we go on still in constitutional jurisdiction. 71, still the same, and it ends there. Then you go on to interest of justice. So my question to you is, it does not appear to me that we have pleaded the alternative basis upon which this court has jurisdiction. Am I correct?
You're talking about the arguable point of law. You are correct, Justice Nuku.
So would that argument, so how does that argument about the novelty of facts fit in within the constitutional jurisdiction of this court?
We deal with it under the rubric of the interests of justice.
Very well. And then you then mentioned 2 other factors. You said the narrow interpretation that was that the SCA did, and you mentioned paragraph 16. I couldn't hear the other paragraph.
26.
26. I looked at paragraph 26. It seems to me the SCA just mentions the authorities that have dealt with the issue of when does the debt arise without pronouncing it itself. So what's the criticism there? What's the interpretation?
So when one reads the entirety of the judgment, so I rely particularly on the last sentence of paragraph 26.
No, I'm still at 60.
Oh, I beg your pardon.
Because it says that the question as to when prescription begins to run has been grappled with in a number of cases in the past by our courts, the golden link, and then it continues, and then it quotes a whole paragraph there. I don't see where it speaks. It gives meaning to what you say it has done.
Justice
I'm just
Nuku.
trying to understand.
Indeed, I appreciate your question. So paragraph 16, you're quite correct. The SCA, what it does is that it talks about the golden link in numerous decisions. It mentions those decisions, and then of course it conducts an analysis all the way going through to paragraph 18, which talk about these facts.
But at paragraph 16, it does no more than just put them there.
So I tie in paragraph 16 with 26. You're quite correct. Paragraph 16 on its own is not what my criticism is. You're quite right.
All right. And then 26. What do you say? Where is interpretation there in 26?
So Justice Nuku, if you take particularly, my emphasis is on the last sentence in paragraph 26.
Legal conclusions from a plethora of judgments of this court. As a general rule, legal conclusions do not constitute facts and knowledge of legal conclusion is not required by a creditor. There's something wrong with that sentence, but I think we know what it means. They are conveying that it is accepted as a general principle that legal conclusions do not constitute facts that are required for the purpose of pleading. Isn't that the correct legal position?
It's correct.
What's the criticism?
It's correct as a matter of general principle, but it's not correct as a matter of an absolute principle. So in other words, what I'm saying is that you can't simply say...
But they say there as a general, sorry to interrupt, they say as a general rule. It reads, that's how it reads there. From a plethora of judgments of this court, as a general rule, and then they leave it there.
That's not what they did, though, Justice Nuku, because what they ultimately did is that they've taken that general rule in its absolute terms and decided that because there was a judicial decree that triggered a certain set of facts, you simply could not rely upon the judicial decree. What we say is something different. What we say is the following.
So I don't quite understand the first part before you move to the second part. Just break it down for me.
Okay. Justice Nuku, what the Supreme Court of Appeal would have effectively is that any legal decision is a legal conclusion, and you can't utilize that as a fact for purposes of precipitating a cause of action at a later stage.
But that seems to be the general rule, isn't it?
That's the general rule, but it's not an absolute rule, and it can never be an absolute rule because that pervades the essence of what our prescription legislation requires of us to do. We're required to take into account facts, and there are cases when the distinction between facts and conclusions of law may be blurred. And this is one of those cases.
But I thought you abandoned that line because you said this is not the Leroux type of case, so you no longer...
No, that's true. I've never advanced the Leroux type of line to start off with to abandon it. I've always accepted this is not a Leroux case because we weren't being advised by lawyers. We were business partners with someone, for want of a better term. So I've always accepted
But essentially, what I was trying to understand from you, I looked at paragraph 16. All I saw, there was a collation of judgments that deal with those principles. And then I look at paragraph 23. It concludes by stating the general rule. So I don't understand how that then becomes a narrow interpretation, which should engage this court's jurisdiction. When the Supreme Court of Appeal merely states what it understands the legal position to be. But we can leave that, and then you say the other third one is the incorrect interpretation of the Prescription Act. Am I right? But now I am looking at the first paragraph of the judgment of the Supreme Court of Appeal. It identified 3 issues that it had to deal with. The first, it had to determine when prescription began to run. Would you agree with me that that does not require the interpretation of the Prescription Act, but what it requires is the application of the Prescription Act to the particular facts that the court is confronted with? Is that fair?
Justice Nuku, not completely. Ordinarily that would be fair, but that requires an interpretation first before you apply the facts to the Prescription Act.
Because sometimes I read judgments, they say this case is concerned with the interpretation of this particular provision. Then you know that that's the interpretation. But here it suggests to me that all that was required was to apply the provisions of this Act as interpreted to the particular facts that were presented to the court.
Justice Nuku, it required an interpretation of the Prescription Act first prior to applying the facts to that case. So the anterior question was its interpretation. What followed was its application based on its interpretation.
Thank you.
We'll take the tea adjournment for 15 minutes, come back at 12:05.
was. If they want to move away from the argument